Thanks, everyone. Please be seated. All right, let me call the case of Ruth versus Carter. Let's take appearances, starting first with the plaintiff.
It's a little confusing. We're not actually the plaintiff, Your Honor, although we're sitting on this side of the courtroom. We got here second.
I usually take appearance plaintiff and work my way down the caption.
Okay. I don't know if the plaintiff is appearing, so.
All right.
I do believe I saw Judge a telephonic
I did too.
appearance for the plaintiff.
I did too. Let me make sure. Are they on? All right. So let me just take a chance to get booted up, guys. And please be seated in the meantime.
Victoria Allen for Plaintiff Shannon Ruth is here.
Thank you, Ms. Allen. All right, let's go down the caption.
Thank you, Your Honor. Good morning. Liane Wakayama appearing on behalf of Nickolas Carter, who is present at counsel's table with me.
Thank you and welcome.
Good morning, Your Honor. Alan Greenberg for the moving parties and counter defendants, Melissa Schuman and Jerome Schuman. Also with me in the courtroom is my partner from California, Deborah Mulgrave. She's not appearing in the case of record, but would be okay if she sits at the counsel table with me to help me.
No objection, Your Honor. And then I do also wanted to state appearances of my co-counsel. I'm sorry about that. Dale Hayes Jr. and Michael Holst is appearing via Blue Jeans.
Very good. Thanks and welcome. Come on up. Are you going to be moving for Belmont PJ?
Depends on the result today, I think.
Got it. Okay, other appearances? We have other people in the courtroom? Just interested people, I assume? Okay, good enough. Mr. Greenberg, this is your motion. Now, this is a bigger courtroom than I'm used to. If you can't hear me, let me know, because I feel like I'm screaming.
I hear you fine back there and probably here too. No one ever asks me to speak up, so it should be okay. Thank you, Your Honor. I want to start with a reminder of why we're here, and then go into how this case should be viewed in the context of the anti-SLAPP motion. We're here because Nickolas Carter is a very public figure, and he is suing Melissa Schuman and her father, Jerome Schuman, for defamation and other torts based on things that they have publicly said about Mr. Carter. When a public figure sues someone based on things that they said about that public figure, the First Amendment makes it a very uphill battle. The constitutional standard of actual malice is well known and understood by lawyers and judges, having been the subject of many U.S. Supreme Court cases over the last 60 years. To recover for defamation or other torts based on speech, a public figure must show constitutional actual malice, which means that the public figure must prove by clear and convincing evidence what was in the mind of the speaker, that the speaker knew that what he or she was saying was false, or knew that it was probably false and said it anyway. That's the standard that's been handed down in many, many cases. Clear and convincing evidence in this context means evidence, I'm just reading from cases that are cited in our papers. Clear and convincing, I'm not making this up in other words. Clear and convincing evidence means evidence that is so clear and strong as to leave no substantial doubt. As the courts have said, it must be so strong as to command the unhesitating assent of every reasonable mind. That's the burden to win. I haven't gotten to anti-SLAPP yet, but that's the ultimate burden for a public figure to win a defamation case. So, in other words, if this case were to go to trial, Mr. Carter would have to prove that no reasonable person could think, even for a minute, that Melissa Schuman is being truthful and that her father, Jerome Schuman, is being truthful. That's the ultimate standard in this case. And now I want to turn to the anti-SLAPP motion. As the court is aware, there are two prongs to the anti-SLAPP analysis. In the first prong, the moving party needs to establish that the challenged statements that they are alleged to have made were made in good faith on a matter of public concern and in a public way. And Ms. Schuman and Mr. Schuman easily met that in this case. I'm not even sure that there's really been a counter argument against it, other than law of the case, which in the papers they argue, but it clearly has no application whatsoever for the reasons set in our papers. But the Schumans have easily met the first prong. They submitted declarations under penalty of perjury in which they explained in a lot of detail why they believed that the statements that they made were true and that they still believe those statements are true as of today. With regard to Melissa Schuman, according to her declaration, and I'm not going to read the whole thing, obviously, but she states that Mr. Carter gave a minor, she was underage for alcohol consumption, gave her alcoholic drinks and then sexually assaulted her in 2 bathrooms in his place before taking her to his bed and taking her virginity against her will. That's stated by her under penalty of perjury in her declaration with detail. Ms. Schuman told her friend, of course this is all from the declaration, Ms. Schuman told her friend Rachel and Rachel's mother, as well as Melissa's own family and her manager. And then Melissa Schuman started seeing a therapist and told the therapist what had happened, that she had been sexually assaulted by Nickolas Carter. All of those statements were back in 2003, and there were declarations supplied by 3 of those people corroborating that that happened. One is Mr. Schuman, and another is the therapist, Ms. Anderson, and another is Rachel Green, who also tells the same story about what happened and knowing about this in 2003. 14 years before Melissa Schuman went public with this in 2017, she told those people that. Now, Mr. Carter in this case is accusing the Schumans of an extortion plot, that this is a recent fabrication to try to hold him up for money, is more or less what he's saying. But in 2017, Ms. Schuman went public and gave the details of this assault in a very public way on the internet. There's not even an allegation or an assertion by the other side that Ms. Schuman or Mr. Schuman ever contacted Mr. Carter in advance of that and said, we're going to go public with this if you don't do something for us, which sounds like an extortion plot, except there's no evidence that any such thing ever happened. Just to put it in perspective, the allegation is that the plot happened years after they went public with the information. In 2017, which is 14 years after they actually discussed the information about the assaults. So, in their declarations, Melissa Schuman and Jerome Schuman both also gave detailed explanations as to why they believe other women who have accused Mr. Carter of sexual assaults, and they've attached police reports and things of that nature. So, having met the burden to show that they were being truthful, they've gone under penalty of perjury and explained all of that, the burden shifts to Mr. Carter to demonstrate with prima facie evidence a probability of prevailing on the claims. And that's a direct quote from the statute. Prima facie evidence, a probability of prevailing. And, of course, that's section 41.660. In section 41.665, the Nevada legislature expressly defined that burden to be identical to the burden that is required under California's anti-SLAPP statute as of June 2015. And that statute hasn't changed in any material way before or after that in this regard. So a lot of the cases that we are talking about are California cases in our papers, but the Nevada legislature says that's what you're supposed to look at for this burden, or at least that it's the same burden. So California's anti-SLAPP burden is the same. It's to show a prima facie case that, if believed, could support a jury verdict at trial. And there's lots of cases we cited. I can cite cases for the court, that, but they're the same cases we've already cited in our papers. Mr. Carter has the burden to show that he has admissible evidence, or will have it at trial, that, if believed, would be sufficient for him to win. So for anti-SLAPP, you don't weigh the credibility of the two sides on the second prong, but there is a burden that Mr. Carter has to come in with evidence that, if credited, despite any, to suspend disbelief, but that's what the court's required to do.
I think the statute's clear on that.
Right. And so he has to be able to win. To win, he needs to prove by clear and convincing evidence actual malice under the Constitution. And while he is allowed to rely on inferences from circumstantial evidence that he presents, the issue is whether the inference, and this is from a case, Christian Research Institute that we cited, the issue is whether the inference is sufficiently strong to command the unhesitating assent of every reasonable mind. So let's look at the evidence. First, Mr. Carter did not deny the unconsented sexual contact in the two bathrooms that Ms. Schuman told about in her declaration and in her public statements. And in her declaration, she declared under penalty of perjury that he pulled off her pants in a bathroom over her objection and orally copulated her. I'm not saying that in this hearing
I've read everything.
because...
I know you need to make a record, but you don't have to be really explicit in the
No,
I've
I'm
read every page of everything.
I understand, Your Honor. I'm limiting that. I just wanted to make a point with it. That Mr. Carter did not deny that in his counter declaration, and did not deny what happened in the second bathroom with another assault. Mr. Carter's declaration describes in his words that he thought he had consent to intercourse in the bed. Neither Mr. Carter's declaration nor any other proffered evidence constitutes proof, let alone proof that is so strong that every reasonable person would immediately agree with, that Ms. Schuman does not believe what she said in her declaration. And the same, obviously, of Mr. Schuman. They've not put forth evidence that proves that Mr. Schuman does not believe what he said, and they have not put forth evidence that proves it by clear and convincing evidence such that no one would ever doubt it for a minute. What Mr. Carter's evidence shows at the very most, is a difference of opinion about whether the sexual contact he admittedly had with Ms. Schuman was with or without consent in the mind of Ms. Schuman. So, because the burden shifted, and for the reasons I just stated, Mr. Carter, he threw a lot against the wall. He has 92 pieces of evidence that he proffers, but a lot of them are hearsay. There was something where they replied, I guess I should address it since we haven't had a chance to do it in the papers yet, but...
You did have an evidentiary objection. I wondered if you would address that now, or if you intend to wait until the reply.
I'm happy to address it now. I mean, the case law is, and including the cases that they cite in their response to the objections, the Sweetwater case of the California Supreme Court and the Sanchez versus Bezos case, which is a 2022 case, just from last year. Those cases make very clear that in an anti-SLAPP context on the second prong, that while declarations are admissible, because that's how we deal with motions, and declarations and affidavits and former testimony under penalty of perjury was what the Sweetwater case dealt with. But that's not the issue of our objections. Our objections aren't to that they filed declarations. Of course, we filed declarations too. Our objection is that some of their declarations, Mr. Coyle, for instance, are replete with hearsay, where they are basically relating things that Aaron Carter supposedly told Mr. Coyle. And Mr. Aaron Carter was not under oath. It's obvious hearsay. And so in the Sanchez versus Bezos case from last year, the court, following the Sweetwater case, flat out said hearsay is barred from consideration on prong 2. I know part of what Mr. Carter's position is that this is not the trial, so we shouldn't even be objecting to evidence. But if one looks at the Sweetwater case, which they're actually citing, the last paragraph of that case flat out talks about objecting in the anti-SLAPP motion, and that in the face of such an objection, the court should not consider evidence that will not be admitted at trial, such as hearsay. And so I just wanted to respond to what they said. And I guess I'll save any further remarks to respond to what they said. Thank you, Your Honor.
Opposition, please.
Thank you, Your Honor. Your Honor, in bringing this anti-SLAPP request, the Schumans today hope this court will dismiss Mr. Carter's counterclaims simply because he's a celebrity. They want this court to strip him of any due process, of any right to defend himself against these heinous and false accusations of sexual assault. But fortunately, as Your Honor is well aware, Nevada's anti-SLAPP legislation only serves to dismiss those lawsuits where it is so obvious on its face that they lack merit early on and are brought for an ulterior purpose. This court has already properly found that Mr. Carter's counterclaim was not brought to harass or intimidate, and each of his compulsory counterclaims sets forth a viable cause of action under Nevada law. That's the law of the case. Importantly, the counterclaim is the product of Mr. Carter finally being able to defend himself, stand up for himself, after struggling alone in silence for years. His counterclaims expose the truth, and in reality, it exposes the dark side of fandom. Sadly, the counterclaim also reveals how the Schumans preyed on a vulnerable and deteriorating Aaron Carter. They manipulated him. They used him, all to extort and defame his brother. Now, Mr. Greenberg talks about the two-prong analysis. He says, we don't disagree with the standard for the first prong, but he admits that for the sexual assault statements, they have to show by a preponderance of the evidence that they were good faith communications that are truthful or made without knowledge of their falsity. The only evidence they produce on this point are their own clients' self-serving declarations and 2 other declarations, as he mentioned, Ms. Schuman's therapist and her friend, Rachel Green. Both witnesses merely parrot what she told them. Neither one has firsthand knowledge of the supposed alleged sexual assault. So at this stage, the Schumans' reliance solely on their beliefs is inadequate, especially given the mountain of contradictory evidence that we have in the record. Specifically, 92 exhibits, approximately 20 affidavits, proving that Mr. Carter did not sexually assault Melissa Schuman or Shannon Ruth, that this is all an extortive conspiracy. Mr. Carter's testimony alone, I disagree with Mr. Greenberg, he specifically contradicts what Ms. Schuman has put in her declaration. Everything was consensual. And he contradicts all of her beliefs. That should be enough. But fortunately, others have come forward, like Tony Bass, who was present that very evening, and he testifies that Melissa Schuman was not sexually assaulted. Why? Because he was lying on the floor, awake 3 feet away from her, with her friend Rachel Green when she says this happened. 15 years later, knowing full well that Tony Bass has had a falling out with Nick Carter, she tries to recruit him. She goes so far to even name drop a highly influential, well-known person from their childhood, meaning Nick and Tony's childhood community, which Tony felt and testified was pure manipulation and attempt to coerce him. He refuses to do it, and he specifically testifies that he was, quote, totally shocked and blindsided by her sexual assault claims. Your Honor, even the Schumans' own evidence that they have submitted to this court contradicts her own story. Rachel Green was her best friend and roommate at the time. She testifies that when they left Nick Carter's apartment the next morning, quote, "I thought everything was fine." Even in Melissa Schuman's November 2nd, 2017 blog, she admits that Rachel got in the car the next morning, turned on the ignition, and exclaimed, "That was so much fun, huh?" So, Melissa Schuman is claiming to have been violently and repeatedly raped in one bathroom, then another bathroom, and then in the bedroom of this small apartment, and all through the night, and all through the next morning. Her best friend, who is there in close proximity, has no idea? How can that be, Judge? It's because it never happened. On top of that, Melissa Schuman's very own documented actions in the public forum confirm that her tall tale is a moving target, ever changing, ever evolving, but always untrue. And to justify their outrageous online defamatory conduct that includes comparing Nick Carter to the likes of Harvey Weinstein, they rely on police reports and fabricated stories of sexual assault from other women. Not only do they lack any firsthand knowledge of these events, but in all of those cases, every single one, law enforcement investigated and did not prosecute. And Your Honor should know that in one of those cases, law enforcement actually determined that the accuser should be charged criminally, who now has a criminal record of filing false police reports. Regardless, relying on this type of evidence does not satisfy their burden, proving their statements were made in good faith that they blasted all over the internet and in the media. Even if the court finds otherwise for the first prong, this counterclaim has already survived anti-SLAPP scrutiny. The only difference today is that Mr. Carter has provided this court with more evidence of the conspiracy. Your Honor, it sounds like, listening to counsel argue, that it's almost as if we're at two different hearings today. The Schumans want this court to issue rulings as if we are at trial, which, don't get me wrong, we look forward to that, and we welcome that with open arms. But today we're here on what their actual request is, and that is dismissal under the SLAPP Act. Just because Mr. Carter is a celebrity, they urge this court to impose immediately a higher burden of clear and convincing evidence. The court can bear that in mind, that's what the cases say, but it doesn't supplant the prima facie standard actually codified by our legislature. In either way, we have more than satisfied either standard, even at this preliminary, pre-discovery stage. As this court is aware, it is extremely rare to have direct evidence of a conspiracy. Now, Mr. Greenberg said we just provide circumstantial evidence. That's not the case. Shane Coyle testified that he actually entered into an agreement with the Schumans and Aaron Carter where they would publicly paint Nick Carter as a sexual predator and share in all the money realized from destroying his image. But soon, Shane Coyle discovered that Melissa Schuman was lying about being raped by Mr. Carter. And Shane Coyle also discovered that her father, Jerry Schuman, knew she was lying about it, but they don't care. They just wanted to get rich off their lies. And it's extremely telling that the Schumans do not even address Shane Coyle's testimony about their conspiracy. And they certainly don't deny it. Instead, they just attack his character and provide this court with video clips doctored to try to fit their narrative. Well, it's a good thing that the internet lasts forever, because in early 2020, Shane Coyle publicly outed the Schumans and Aaron Carter's conspiracy aimed to extort Mr. Carter, which occurred way before this lawsuit. And Aaron Carter himself publicly exposed the Schumans and Shannon Ruth's lies on social media before he unfortunately passed. Your Honor, falsely accusing someone of a crime like sexual assault is inherently malicious. Actual malice is presumed. That's why our laws, Nevada law, recognizes it as a defamation per se tort. But again, we're here on anti-SLAPP. This is not trial, not yet. So as before, with the mountain of evidence Mr. Carter has provided, the counterclaim not only satisfies the minimal merit standard, but also the substantial merit prong. Now, to be clear, today is the question about whether the counterclaim is a meritless SLAPP suit. It's not. Not with this much in factual dispute, not with how detailed the counterclaim is, and not with this extensive evidentiary record before discovery has even opened. To address the admissibility of evidence, that Sweetwater case is still good law in California, 2019, And our statute itself, that's what Mr. Greenberg ignores, our statute itself requires this court to consider evidence, written or oral, by witnesses or affidavits that may be material. That's what anti-SLAPP is. So, Your Honor, this is so far off of what our anti-SLAPP laws were intended and designed to prevent early on in a case. Otherwise, that would mean any celebrity wrongfully and publicly accused of sexual assault would be deprived of any right to assert a counterclaim in their defense. And that's simply not the law. So we ask that you deny the instant motion, and given your clear and comprehensive rulings about, meeting the second prong as in the prior proceeding, we believe that the Schuman's instant motion was done not only vexatiously, but it's frivolous. And so we also ask that you award Mr. Carter attorney's fees and costs. Thank you.
Thank you. Can you reply, please?
Thank you, Your Honor. I did not hear counsel say that, or suggest that Mr. Carter had proven so that any reasonable mind would immediately agree with his point of view based on the declaration of Shane Coyle. The fact that, and the other declarations that they submitted, that's the burden. And so we could talk about the purpose of anti-SLAPP all day long, but there's many, many cases, and there's a First Amendment that applies to public figures and celebrities, and we're not making new law here on that. There's the cases, include the, just most notably for Nevada, we cited the Pegasus case, Pegasus versus Reno newspapers. California, Reed versus Gallagher, Hahn versus Tran, Christian Research Institute, Annette F. They're all on point. In the Annette F case, somebody accused their domestic partner of being convicted of something, and the court said, well, they got like a TRO, so it's close enough for purposes of constitutional malice. In other words, I heard a complaint that supposedly by the standard that we're holding Mr. Carter to, that no celebrity can ever bring a defamation case and get by an anti-SLAPP motion. That's not true. In fact, it didn't happen in this case when there was an anti-SLAPP motion, and the counter-defendant did not win the motion. But that's a very different case, because in that case, and in other cases where celebrities have prevailed, there's something demonstrably that they raise that, if believed, demonstrably means that it didn't happen, such as, I wasn't there. I never was in the same room with this person. That, if believed, would be clear and convincing evidence that anyone would agree if they believed that the person wasn't there. But when there's a difference of opinion about we're looking at what's in somebody's head, the actual malice standard has nothing to do with ill will malice. This is a constitutional First Amendment standard that applies in all 50 states. And the standard is whether the speaker, the alleged defamer, knew that something was false, or knew it was probably false and said it anyway. And when somebody accuses somebody of something and they weren't in the same place, that's easy, and the anti-SLAPP motion gets denied. But when they were in the same place, and it comes down to, is the alleged defamer telling the truth from their perspective, where they think it's true, they can have a difference of opinion. That's not good enough. If you look at these cases that I just cited and all the other ones on this point, it has to be clear and convincing. It cannot be based on speculation and it cannot be based on hearsay. And so when someone like Mr. Coyle, if you read carefully his declaration and his supplemental declaration, he casts a lot of aspersions. He's on their side, obviously, but he never says anything that, if believed, would be clear and convincing evidence of anything. It's all conclusions and hearsay from Aaron Carter, who himself was allegedly drawing conclusions. Like, I believe this, I no longer believe that. That's not evidence. That's not testimony. It's not admissible, and it's not clear and convincing evidence. And so have not met, we have met our burden, they have not met their burden, the anti-SLAPP motion should be granted. Thank you.
Thank you both. Matter is submitted, this is the ruling of the court. The moving party here did meet your burden to shift the burden of proof to the defendant counterclaimant. So, but in the opposition, you met the statutory standard to survive this motion. So the motion will be denied. The appendix, I realize the appendix is not perfect, but there were 92 examples of things. And I think the evidentiary objections were not all well taken in this case. And the other thing, as I've mentioned in previous cases, it's a compulsory counterclaim. If it hadn't been asserted, the right would have been lost to pursue those causes of action. And it troubles me that anyone not have the ability to give themselves a defense. So the motion fails. I don't find that the motion was vexatious or that it was frivolous. I won't award attorney's fees. If this case goes to trial or proceeds, there will be a time and a place for that to be determined, but it's too early at this point. Any questions, any comments?
Understood, Your Honor. We'll prepare the order and I'll ratify Mr. Greenberg for review.
A civil form of order.
Thank you.
And you and your team will have the ability to review and approve the form of a simple order?
Yes, we'll review it.
Good enough.
Your Honor, if there was just a point of clarification, just since we're on the record, I think Your Honor referred to this as a compulsory counterclaim. It may be against Ms. Ruth, but I don't know that it is against my clients who are not parties to this case. So I just wanted to say that.
Oh, so noted for the record. Okay. Anything else before we conclude?
No, thank you, Your Honor.
Thank you.
Thank you all.